Hello, everyone. We will get started in about 5 minutes. You are in the last session of day 3 of Ethics Week 2023, the overview of recent Open Meetings Act and FOIA advisory opinions and advice. I am Niquelle Allen. Just want to let you know you're in the right place and to thank you for joining. We will be getting started shortly. Again, good afternoon and welcome to the last session of day 3 of Ethics Week. I will start on time. I'm looking at my temperature gauge. It is 76 degrees outside and sunny, and I do not want to keep you all away from this beautiful weather that we're having today in the District of Columbia. We are the Sunshine Office, so I will not keep you all away from this sunshine that we have today. I want to again thank you for joining us during Ethics Week in general. We hope that you've got a lot out of it, and we appreciate your presence and your time with us this week, and in particular today. As you've seen, the Office of Open Government, we are a small but mighty team, and we are here with a commitment to government transparency, to making sure that the District of Columbia government is transparent and operates in a way that allows our citizens to be informed about what the government is doing. Um, and that has been our theme today, openness, transparency, and information. We are the A in the accountability, and we thank you for partnering with us in that effort to make the District of Columbia government accountable to the people. And I'll give it a minute or so before we get started. I see it looks like we're getting a critical mass of you here. Um, so this is the last session of today, session 5, the overview of recent OMA and FOIA advisory opinions and advice. For those of you all who don't know me, my name is Niquelle Allen. I am the Director of Open Government, and I will be your instructor slash facilitator for this afternoon. You have met most of my colleagues today. They are also here with me. They will assist me in answering questions. We had the chat open. I can see the chat. They can also see the chat. If you have questions, please put them in the chat. I believe that Kevin Brown is here with us as well. And if you would like to talk to us, um, I believe we have the hand raise function available. So raise your hand and he should be able to promote you. So you should be able to ask a question if you'd like to do that as well. So I won't keep you. I'm going to get through this material pretty quickly. So let's get started. So today you've learned about the Office of Open Government. We are an office within the Board of Ethics and Government Accountability, which you've learned. This morning you heard my remarks and I talked about electronic meeting best practices. You know, we ensure government transparency by advising on the implementation of FOIA. You heard about who wants to be a FOIA officer. We ran through questions and you learned about the benefits of that. This afternoon, you learned that we enforce the DC Open Meetings Act, and you learned from Attorney Skirbo about the Newcomer's Guide to the OMA. And you know we have a website, which is open-dc.gov, and you just heard from our RT specialist, Kevin Brown, about how to post on the central meeting calendar, which is one of the main features of that website. So now we're here to talk about our advisory opinions. That's one of the main things that we do as the Office of Open Government. BEGA's enabling legislation requires the Director of Open Government to issue advisory opinions regarding compliance with the DC Open Meetings Act. So the responsibilities are set forth in DC Official Code Section 1-1162.05C. They set forth the responsibilities of the Director of Open Government, and one of those is to issue those advisory opinions on the DC Open Meetings Act. Our enabling legislation also permits the Office of Open Government to render advice on the implementation of DC FOIA. So we issue Open Meetings Act advisory opinions generally in response to Open Meetings Act complaints or as a result of our regulatory public body monitoring. I told you a little bit about that this morning. Our attorneys do monitor public body meetings, and we do get information about compliance through that attendance. But most of our advisory opinions are as a result of complaints. We issue FOIA advisory opinions at the request generally of government agencies, or we issue them sua sponte. We have outside entities that request that advice, and I provide that response on my own to advise that government agency who's the subject of that request. So in this last day of training, I will cover a few of the advisory opinions that we issued during fiscal year 2023. The text of those opinions are published on our website, open-dc.gov, under the Documents tab. I will also go over some legal advice rendered by the office. As you may know, OOG's legal staff also issues memoranda and other letters and documents to assist attorneys in DC government, as well as FOIA officers and others with open government issues. So let's just get started now with the OMA advisory opinions. So the topics we're going to discuss today are ANC meetings, public body definition, closed sessions, and electronic meeting notices. So the first open meeting cases that I'm going to talk about are ANC meetings covered by the Open Meetings Act? So when OOG receives an Open Meetings Act complaint, our threshold question is whether we have jurisdiction over the matter. We can only resolve Open Meetings Act issues when the public body in question is subject to the Open Meetings Act. only public bodies as defined by the Open Meetings Act are covered. The term public body does not include District of Columbia courts, the mayor's cabinet, advisory neighborhood commissions. Private not-for-profit organizations are also not considered public bodies as contemplated by the Open Meetings Act. So when we receive an OMA complaint about an entity's meeting that is not considered a public body, we will draft an advisory opinion that dismisses the OMA complaint. So as you see here, this past fiscal year, we issued 3 complaints dismissing matters that concerned ANC meetings. ANCs have their own law that governs their own meetings. The Advisory Neighborhood Councils Act of 1975 governs ANC meetings. Our enabling legislation does not give us enforcement authority, and neither does that legislation over their meetings. Um, so once we do that dismissal in our analysis, we refer those matters to the Office of the Inspector General. We also let the Office of ANCs know that there has been this complaint. So as you also see here, DC Official Code Section 2-5743 specifically excludes ANCs from the definition of public bodies in subsection F. So we really have no authority over ANC meetings. We do provide help and assistance with them through, I think you heard earlier, our parliamentary procedure portal, and we also provide them with FOIA advice. But in these opinions, the nature of those opinions were to set out these rules and to do an actual dismissal. So the next advisory opinion dealt with task forces. So the question was, is a task force a public body subject to the Open Meetings Act? So OOG, we were asked whether the mayor's task force on automated traffic enforcement, equity, and safety is a public body subject to the Open Meetings Act. So this entity was created to research and provide recommendations on DC's automated traffic enforcement program. Their enabling legislation did not explicitly define it as a public body, so they reached out to us so that we could figure this out for them, which we encourage them to do, and that's what we're here for. So we looked at the Open Meetings Act definition of a public body, and we also looked at the legislative history of the Open Meetings Act to determine if task forces are in fact public bodies. The committee report that created the Open Meetings Act law included the term task force in its definition of a public body. So we deduced that it was the council's intention to include task forces in public bodies. We also looked at other organizations, and this is all in the opinion, that are task forces and had enabling legislation that had a certainty around it that included them in the Open Meetings Act. So we opined that if these groups were included under the Open Meetings Act as a public body, then this one should be as well. And lastly, we looked at what the task force actually did. So it kind of looks like a public body, acts like a public body. So we believe that the intention was there, although it was not specifically stated, for it to be considered a public body under the Open Meetings Act. So as you see here on this slide, I have the actual definition of a public body. Now, it does not say task force, but it says any government council, including the Council of the District of Columbia, board, commission, similar entity, including a board of directors of an instrumentality, a board which supervises or controls an agency or advisory board that takes action, official action by vote of its members, convened for such purpose. So when we looked at this task force, it did all of that. And again, we looked at others that were similar, and we looked at the legislative intent. So that caused us to conclude that this entity was covered by the Open Meetings Act. And I see a question from Josh Turner. Is the idea that a task force is the kind of advisory body described in the definition? Yes, that is exactly the idea. And again, if you just think about the overarching principles of the Open Meetings Act, again, it's that the public should be able to observe the government in action and see why and how we're making decisions as government officials. So this particular one, the audit, I mean, we all are impacted by cameras, by speed cameras, so to speak. So there is a public interest in seeing how this particular body is having discussions about this issue that is of great public interest. So as they're deliberating and discussing, I think we as public, not stepping outside of ourselves as government officials, but just as members of the public, it would make sense that if we as a government are creating something like this, that the Open Meetings Act would allow the public to watch and see how this issue of great importance is being discussed and decided by these government officials and the recommendations that are going to come out of it. So that's what our advice was, and we concluded that this task force's meetings are covered by the Open Meetings Act. Now, the next group of cases deal with justification for entering into a closed session of an open meeting. So as we discussed earlier in our OMA training, public bodies may only discuss the matters listed on the meeting agenda in the closed session. So you're required to give notice of your reason for closing the meeting. So the agenda has to have a statement of the intent to close with the citation of the reason for closing the meeting under DC Official Code Section 2-575B, and a description of the matters to be discussed. And in the public part of the meeting, there has to be a motion by the public body during the open session to close the meeting, to enter into the closed session, and that has to be approved by the majority of the members present at the meeting before entering into the closed session. So in our first matter, it dealt with the Stabilization and Reform Board of Commissioners. So in this matter, we got a complaint that this board entered into a closed meeting improperly based on what they put in their agenda. The complainant said that the meeting was stated to be closed because there was a training of staff members, which was proper under the Open Meetings Act, but they said what actually happened wasn't a training, but was in fact a policy briefing. So we had our OOG attorneys to investigate, and they looked at what happened during the meeting. First, we found that the board did properly close the meeting, as I just discussed. They went through all the proper processes. They had proper notice. They put the proper citation that it was staff training, and we dispensed with that. Then we went forth to review the actual closed meeting, and we had discussions with them, and we found that the policy briefing was in fact a training. We found that calling it a policy briefing, I think, which was just the kind of title, didn't negate the fact that it was in fact a training. It had all the indicia of training. It had a PowerPoint presentation like what I'm presenting today, handouts, discussions, and the like. So we pretty much concluded that when you just call it something different, that doesn't negate what it is. So kind of similar to what we looked for with the task force, you had to look at what's actually happening. So calling it a policy briefing, what the people were actually doing was training new members on things that were happening with their body. So we found that they did properly close the meeting and they did properly have a staff training. However, we did notice that they had a problem with quorum in the beginning of the meeting. So we found that they violated the notice of meetings provision because they didn't start until very, very far outside of the time they said they would. So it was over an hour before they started. So we found that this violated the notice of meeting provisions because they deprived the public of meaningful notice by waiting over an hour to start the meeting. They should have probably just resumed at another time to give the public the opportunity to come. We found that it was unreasonable for them to wait as long as they did. And now we do know that sometimes it is an issue getting quorum, but it's unreasonable to have people wait like an hour and a half to start a meeting, and that kind of negates the notice that you have provided uh, to the public to transact your business. So the second advisory opinion we did regarding justification for entering into a closed session dealt with, I guess, the artist formerly known as the ABC board. Um, this was a reconsideration actually of a previous um, advisory opinion that we did regarding the ABC board's adjudication of an establishment. The crux of the issue here concerned the stage of investigation that was noted by the ABC board. Here, we found that the board, which is ABRA, because ABRA, the agency, does the notices for the board, the closure justification for a closed session in the matter was to discuss an ongoing investigation, but the investigation had in fact ended. So what they were really doing was deliberating about the license. So the investigation was over, so they should have noted that they were meeting in closed session to exercise their quasi judicial function. So they did not close the meeting under the proper justification. So that was the issue here, and that was the nature of this advisory opinion. So one of the things that we note to public bodies, and especially one that has adjudication such as this, that it is okay to note multiple reasons for closure, and then you're covered because theoretically when you're looking at the ABC board looks, and they're not called that now, but they look at multiple establishments. They have investigations going on, they have deliberations going on, so it would have been totally appropriate in this matter for them to have cited both reasons for closure.
Doctor?
Yes.
There are two questions. The first is, can you opine on what the outer limit in terms of waiting for a quorum to be established would be acceptable? And the second is, in the facts just presented, how could the body postpone a closed session if they didn't have a quorum to act?
Okay, I'll take the second question, and then if Attorney Weil is on the line, I'll have him take the one about the outer limit. So they should postpone the whole meeting, not the closed session. So this was the meeting itself. So if you don't have a quorum, you don't have a quorum to meet at all. So you can't So as we learned from Attorney Skirbo's training, that is one of the prerequisites to having a meeting is you have to have a quorum. So if you cannot get a quorum, you have to stop. Okay, so
As for the first question, Director Allen has given informal advice up that half an hour was too much. And as far as where the line is, I like to avoid the question by saying it's not necessary. So if this meeting is scheduled for 4:30, then start the meeting at 4:30. If and then if a quorum hasn't been achieved, we haven't had to approach what the line would be yet. I'll leave it up to Director Allen to say if there's a number of minutes sort of shy of 30, but 30 was too many. But in any case, the meeting should at least get started when it's supposed to get started. And then if it has to recess to wait for more folks to show up, that's another thing. But at least as a courtesy to the public and as a matter of parliamentary procedure, at least procedurally get started when when it's supposed to. And then Director Allen, it's up to your pay grade as far as what happens as far as official business.
and I think what you said is proper to recess and come back. So these folks just kind of stayed, so they didn't do anything. So if we could say, hey, we'll take a recess for a time certain, and we'll come back to see if we can get quorum. Then you're not kind of lingering. You're following procedural rules at least to maintain some type of order. You're giving folks notice that we have a problem. We're trying to get it together. So is a delay due to lack of quorum, a change in schedule requiring a new notice, and if not, is a delay a violation? Yes, if you don't have the requisite quorum, and you would have to have a new notice of the meeting, I believe. I think, is that Attorney Wiles, this is a parliamentary procedure question.
Well, Josh
If
Turner's
they recess.
touching on it. Yeah, it's also an OMA question. So if you've had to cancel the meeting at the last minute because you're not going to be able to get what you want to get done because you don't have enough people, have you just committed an OMA violation because you canceled the meeting? No, but then the rescheduled session, I don't know if it's obvious, but the rescheduled session would then, yes, have to comply with the OMA with respect to notice. If you know right away, hey, we're all gonna be able to do this next week, let's just set up a special meeting for next week at the same time, then post that new notice. But in the meantime, no, you haven't violated the OMA by not dragging everyone out of their sick beds to hold the original meeting as scheduled. If that was your question, Josh Turner.
Okay. Okay, you got it. All right. Okay, well, I think we've got that one, so let's move forward. So the next issue is notice of electronic meetings. We touched a little bit on this morning. So we did have to issue an advisory opinion on this, and this was in regard to a local school advisory team. And In this case, as we discussed this morning, when you have an electronic meeting, a public body must give the requisite notice on its website. And here, this public body did not do that. They did not provide that information on their website or on OOG's central meeting calendar. So again, we impressed upon this public body that they had to provide the public with a link to attend or view its monthly meetings and provide this timely notice and provide the electronic meeting recording. And this public body did not do any of those things. So that wraps up our Open Meetings Act advisory opinions. So next, I'm going to move on to Freedom of Information Act advisory opinions. So we're going to touch on today 4 issues with FOIA. The first is body-worn cameras and Exemption 2. The second are entities that are actually subject to DC FOIA. The next is disclosure without a DC FOIA request. And the last, denial letters. So our first case dealt with body-worn camera footage. So this was a Metropolitan Police Department matter, and it dealt with the redaction of body-worn camera footage, and the justification for that redaction was FOIA Exemption 2, which is the privacy exemption. So we received a request from a FOIA requester asking us to review the Metropolitan Police Department's denial of their FOIA request, and they wanted us to advise MPD of whether or not they properly applied the DC FOIA exemption. We advised that MPD was partially correct in their application of DC FOIA Exemption 2. The video at issue was a motor vehicle pedestrian accident, and MPD redacted the faces of on-duty officers, which we found was not a correct application because there's no expectation of privacy for uniformed officers working in public, and redacted faces of third-party passersby, which we found was correct, and the driver, which was also correct. So, as you may recall from this morning, DC FOIA Exemption 2 permits the government to withhold records if they contain information of a personal nature where the public disclosure thereof would constitute a clearly unwarranted invasion of personal privacy. So in a previous FOIA advisory opinion, we found that the redaction of MPD officers' personally identifiable information under Exemption 2 is not a proper use of that FOIA exemption. Perhaps Exemption 3 applies, that's the law enforcement exemption, but not Exemption 2. Also, we opine that in the absence of a public interest, there's no reason to release that third-party bystanders and drivers information. This is going to be their face blurred out. That's the redaction in this body-worn camera footage because they do actually have a privacy interest. In the opinion, we cited a 2016 Mayor's Office of Legal Counsel appeals case. It's called Gibson. That was directly on point to justify our conclusion as the facts were substantially similar and warrant the same result. And one of the things that case had FOIA officers to do is to conduct a public interest analysis. That was unnecessary in this case because there was none articulated by anyone. So we didn't go there either, but we did find ultimately, we advised MPD again that Exemption 2 does not apply to the redaction of individual officers when they're in public in uniform, that they don't have a personal expectation of privacy. But in those cases, in these body-worn camera videos, now there may be some type of investigatory privilege or something like that, but not exemption 2. Now, the next matter we advised on are dealt with governmental entities that are subject to FOIA. So specifically, are non-governmental entities subject to FOIA when they perform a governmental function? So we dealt here with the Humane Rescue Alliance. So we found that entities that perform functions for DC government agencies that are not actual parts of the government cannot be subject to FOIA in the same way DC agencies are. So the Washington Humane Society is a nonprofit organization that conducts animal cruelty investigations on behalf of DC government pursuant to DC law. And the Humane Rescue Alliance is an entity within that organization. And it performs these investigations, and it's the entity that actually received a FOIA request. In this entity also, we call it HRA, it actually creates government records. But we found that even though HRA was chartered by Congress and is operating under DC law, it's not subject to DC FOIA. It's not a public body. Again, it's public body is defined as a defined term within FOIA, just as it is in the OMA. So it is not a public body that is subject to FOIA. We found that DC Health, the agency that managed the entire process, is the proper body to receive the FOIA request. So DC Health is responsible for handling the FOIA request and kind of being the intermediary, I guess, so as it were, to getting the information that or the records that HRA may create due to their contractual relationship. And it is a contractual relationship that's created by law. So it was a very interesting issue to research and to read about. So we hope you, if you're interested, that you will read our opinions. They are on our website. So in the next case, we deal with these pretty frequently. You may have heard of this before. It's kind of, I guess, what we would call our DC reading room cases. This is our matters. This is the affirmative disclosure without a FOIA request matters. So we receive grumblings and complaints about these agencies who have not made information available without a FOIA request. So this time it was the Rental Housing Commission. So we advised that they were not fully compliant with the mandatory disclosure provisions of DC FOIA. So all final orders created after November 1st, 2001 that are not subject to statutory exemptions have to be publicly available on a website to be compliant with DC FOIA. So since 2001, agencies are supposed to create an electronic reading room that contains materials, policy statements, adjudications of cases. A lot of agencies, as you all probably know, have just created a DC FOIA tab that just has all this information there where people can find it. This is an agency that was just not in compliance. So our opinions just advise that they comply. We've also advocated, we do advocate before the council and others that money be set aside for this purpose, because 2001 is a very long time to have had this requirement and not have provided the means for people to comply. And our last matter is a significant of a denial letter incorrectly stating the law. So this is another MPD case, or it's a case matter because we're not in court. So it's MPD matters, another MPD matter that we advise them on because again, we do not have any authority to make people do things. We are advising on the implementation of FOIA. And In this case, this concerned the denial of a FOIA request for police disciplinary records. And it concerned the way MPD responded to the request. So they denied the request. Um, I'll start with what they did correctly. We found that the basis for the denial was proper under DC FOIA. However, the denial letter contained an incorrect statement of the law. So the basis was the section 134 of the Comprehensive Policing Act. It amended DC FOIA to prohibit the use of the personal privacy exemption to categorically exclude the release of disciplinary records for MPD. It also implicated Section 135 of the Comprehensive Policing Act, which amended the Office of Citizen Complaint Review Establishment Act of 1998 to require the Office of Police Complaints to establish and maintain a database that includes information related to sustained allegations of misconduct. So NPD, in its FOIA response, incorrectly stated that the release by posting of certain disciplinary records is not in effect. So what actually is true is that sections 134 and 135 are current law, but the provisions are not yet funded. So that was the correct statement. So what we recommended, and actually what MPD has done in at least one instance, is that they send these FOIA requesters a corrected letter that has a correct statement of the law, just so they can close the loop and be technically correct, because we think that that is important in executing your duties as a FOIA officer. So the last matters in our presentation are formal legal advice. So we provided and continue to provide guidance for remote meetings post COVID-19 public health emergency. As some of you may remember, probably do remember, we talked about it today, the law did change significantly on FOIA as well as OMA when we had the COVID-19 public health emergency. So we provided a series of letters and advice to FOIA officers as well as administrative points of contact on the changes to those laws. We recently, on October 17th, updated that advice to let everyone know that public bodies are now required to physically post meeting notices 48 hours or 2 business days before their meeting, whichever is greater. And public bodies can continue to meet electronically, but and there's still this no public right to attend live and in person currently. So the Office of Open Government provides this type of legal advice and legal notices, and we'll also put this type of information in our newsletter. So that's it for my presentation on advisory opinions and legal advice. So as you've heard throughout today, this is the Office of Open Government staff. You can contact us at opengovoffice@dc.gov. We're all on Teams. Our email address is generally our first name, last name, and you can find us in Microsoft as well. So if you have any questions, please put them in the chat. Otherwise, please go out and enjoy this beautiful day. We have day 4 coming up tomorrow. We'll go back to our traditional ethics training. But again, I want to thank you all for participating in Ethics Week and participating in Open Government Day. I'll call it Open Government Day. And thank you again for all you do, for your attention, and for being advocates for open and transparent government. So thank you so much. All of our presentations will be emailed to you, and if you don't get something, feel free to email me. I'll make sure you get it. I'm my first name dot my last name at dc.gov. And I hope that you all have a wonderful rest of the day. Yes, and please enjoy these sunny days while we have them. And take care. And thank you so much for your time and your attention always.